All right, I'm going to call the meeting of the Sentencing Guidelines Commission to order. Today is June 4th, 2026, and I will ask Director Wrights to take the roll.
Thank you, Madam Chair. Roll call. Vice Chair Middlebrook.
Here.
Present. Commissioner Castro.
Here.
Castro present. Commissioner Eid.
Present.
Eid present. Commissioner Fraze.
Present.
Fraze present. Commissioner Keefe.
Present.
Keefe present. Commissioner Ladd.
Present.
Ladd present. Commissioner Mazzaros. Mazzaros absent. Commissioner Moore. Commissioner Moore absent. Commissioner Morin.
Here.
Commissioner Morin present. Commissioner Mueller.
Present.
Mueller present. Commissioner Reeves.
Present.
Reeves present. Commissioner Saxena.
Present.
Saxena present. Chair Mitchell.
Here.
Mitchell present. Madam Chair, there are 11 members present, 2 members absent.
And so with that, we do have a quorum. First item on the agenda is approval of the adoption and approval of the agenda. So I would entertain a motion to approve the agenda. So Commissioner Middlebrook moves, Commissioner Reeves seconds. Do we have any discussion on the agenda? Hearing none, we'll vote on that.
On the Middlebrook motion to adopt the agenda, Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yay.
Castro, yes. Eid?
Yes.
Eid, yes. Fraze?
Yes.
Fraze, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros absent. Moore? Moore absent. Morin?
Yeah.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Next item is approval of the draft meeting minutes from the May 7th, 2026 meeting. Those were sent out last week, so you should have had a chance to review. I would entertain a motion to approve the minutes.
So moved.
Commissioner Eid makes that motion. Do we have a second? Second. So Commissioner Middlebrook seconds. Any discussion on the minutes? Hearing none, we'll take a vote on that.
Do the Eid motion to approve the May 7th, 2026 meeting minutes. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Eid, yes. Fraze?
Yes.
Fraze, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros absent. Moore? Moore absent. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 11 votes in favor, no votes opposed.
With that, the motion is approved unanimously. Okay, so now we'll move on to item 4, which is sentencing guidelines changes related to the 2026 regular session laws. So I just want to let everybody know that this is the main event today. We do need to get through number 4 because all the decisions that we make today will be put forward to a public hearing in July. So if we get through nothing else today, we will get through this one. Anything else is sort of optional, except number 5. 5 has to be on there too. And what I will say is we have a lot of items on this, and so I'm trying to think about the most efficient way to work through the proposals. To me, items I believe it was 5, 6, and 7 are the more complex ones within this grouping. And so I'm kind of wondering if we could, let me just make sure that I got that number right.
Let me put 2 on that.
You put 2 on that list as well? 2, okay. 2, 5, 6, and 7. So this is what I'm thinking. Can we review 1, 3, and 4, and then see if we can do a motion to take care of those?
Sure.
And then we can move back and go through 2, 5, 6, and 7 and see where people are landing. If we have to take a vote item by item, we will. If we can do them as more of a package, we'll do it that way.
Do you want to include item B as well?
Oh, yeah,
in that?
yes, let's do that.
Hopefully that's.
Yeah, B is, thank you. So we'll do 1, 3, 4, and B first and try to work on that as a package that we'll take a motion on, and then we'll go to the ones that are a little bit more difficult.
Thank you, Madam Chair. So this was a very productive legislative session, I would say, especially for even numbered so-called bond here, and given the very narrow partisan divide in the legislature, they did come up with a surprising amount of legislation. They also kind of squirreled it away in a surprising number of different session laws. Typically, we see most of the important laws in one place in kind of an omnibus crime package, and for whatever reason, they were in a number of different crime packages this time, which presented your staff with the challenge to make sure we found them all. I hope we did find them all. So we'll begin with and the order is almost random. It's the order in which they were passed by the legislature, basically, and sent to the governor. So the first crime is changing the crime of coercion. So there's an existing crime of coercion, and it does have a misdemeanor level and 2 levels of felony. It all has to do with money and how much money the victim lost as a result of the coercion. So it's essentially threatening to do something that one would not be entitled to threaten to do. And there's a whole list of things that you might threaten in order to get money out of the person. And that's essentially the crime of coercion. One of the newer ways of committing that crime is not new this session, but newer within the last few years is this subdivision 1(6), which is the threat to disseminate a private sexual image in violation of 617-261. 617-261 is also a new crime that the commission had to rank fairly recently, where one threatens to disseminate a private sexual image, essentially. So this is the idea that you'd be trying. Well, it's the crime is disseminating private sexual image. This is threatening to disseminate private sexual image, and tragically, there have been some cases where people lost their lives as a result of this in a situation where essentially the extorter, the coercer, was trying to get a lot of money out of some of these cases involve children. Actually, cases I'm aware of involve basically teenage boys who ended up committing suicide because they weren't able to pay the money and they couldn't stand the thought of these private sexual images being disseminated. So, and that's really the gist of the law here is just measuring the severity of the offense based on pecuniary gain or loss doesn't make any sense in that kind of thing. So there are 2 new severity levels established, or two new felonies established here. One is a 10-year felony if the violation is a substantial factor in the victim suffering great bodily harm, and a 15-year felony if the violation is a substantial factor in the victim suffering death. Just say editorially that I'm gratified that the legislature, I know there's at least one legislative staff around here, gratified that the legislature did distinguish great bodily harm and death. Makes it easier for the commission to rank something if 2 very different levels of harm are separately ranked, because obviously the level of harm is one of the main things that you look at when you're ranking a decision. And we kind of gave you the background in the last meeting to save time here, but what we did talk about goes into ranking these cases. So in each one of these cases, we're going to have a staff recommendation. Please don't think of that as anything real. It's obviously your decision. These staff recommendations, for the most part, are just sort of staff's best guess at what you might do. And we have to make a guess as to what you might do because we have to do fiscal notes on all these. And in order to do that, we first need to know what the severity level is. So we do take a guess at what you might do. But please don't think of that as being anything that's in any way binding or precedential with respect to you. It's It's just staff's, us basically trying to read your minds in advance, which is not an easy thing. So based on how other, death crimes are ranked, we recommend, ranking, the offense resulting in death at severity level 9 and the offense resulting in great bodily harm at severity level 8. And tried to come up with sort of a succinct way of describing these crimes in the guidelines. And this doesn't necessarily roll off the tongue, but at least it doesn't use too many words, but still gives you, I think, puts somebody on notice as to what the crime is generally about. We're calling this coercion by private sexual image threat resulting in death, and then coercion by private sexual image threat resulting in great bodily harm. So that's the staff recommendation, Madam Chair. And so we're gonna take these, we're not gonna take these one at a time, we're just gonna.
We won't vote, but people can ask questions.
Okay.
Right, so Commissioner Eid.
I just wanted to ask a quick question. I noticed that for, I think, almost every single one of these, the staff didn't make a recommendation about whether it should be added to the guidelines offense lists, like offenses eligible for permissive consecutive sentences and severe violent offenses. Is there a reason why the staff didn't make a recommendation about that? Or, yeah, I just was wondering.
So I guess something I should disclose up front is staff has a very status quo bias, right? So if we're gonna do things the way they've always been done, and I'm not saying that's a good thing, but I'm just disclosing that that is our bias. So if the existing coercion offenses are not on the list of offenses that are eligible for consecutive sentences, for example, we're probably not going to recommend that it go on a list. But certainly if the commission's interested in doing that, that's something that the commission consider.
Can I just ask one follow-up question? So that makes sense to me. I just, I read it as making no recommendation one way or the other about adding, but it sounds like this is affirmatively recommending not adding it. Is that the better way to read it based on what you just said? Because this applies to almost every single one.
Essentially, yes. Yeah. There is like at least one case where we're adding it to the consecutive list because it's already on there. I think it's changing it. But yeah, maybe a better way to put it is it's not staff's recommendation to change those lists. And the list will not be changed unless the commission changes.
Thank you.
So as we go, if there is something that any member feels should fall in that category, then this would be a good time to raise it, basically.
All right, and then we're going to skip 2 and move on to 3 as I didn't chair, so please. So,
Yeah,
so this is a new child grooming offense. You have a footnote here that it wasn't signed as of May 28th, 2026. We found out later it was signed on May 27th, 2026. Whether that's because the revisor's office just hadn't updated the website yet on May 28th or because we needed to refresh our browsers, I'm not sure. But in any event, that's technically not accurate that it wasn't signed as of May 28th. It was signed the day before. But it kind of just shows you what we're dealing with here. A lot of these were, it took the reviser a while to post them on the website. And so it was a challenge to get this to you by last Thursday. Grooming is engaging in a deliberate pattern of conduct to methodologically develop a false trusting relationship with a child. It's intended to strategically manipulate the child to engage in sexual contact with the person in the future time. But it also has this element. The first element is while also expressing to the child the desire or intent to engage in sexual contact with that child. So this grooming offense is placed in the same statute of soliciting a child to engage in sexual conduct. Okay, so a couple of things about this. One is there's in my analysis of this bill, there's not a lot of daylight between that first element of expressing a desire to engage in sexual conduct with a child never mind the second element, all that grooming stuff, that's all new, but the first element of expressing a desire to engage in sexual contact with a child sounds an awful lot to me like the existing crime of soliciting a child to engage in sexual contact. Especially given a Supreme Court interpretation, and I quote in the footnote from Justice Page's dissent on that, where they say pretty much any sexually explicit conversation between an adult and a child is probably going to qualify as soliciting a child to engage in sexual conduct. So based on that broad interpretation of the existing crime, we didn't estimate that there's going to be a lot of impact. It's probably, from a ranking point of view, probably also an argument to be rank it at the same severity level. Now, what does that give us then? So that gives us 3 crimes that are in 609352. There's the existing soliciting a child to engage in sexual conduct. A child is defined as somebody under age 16. There's also the existing crime of electronic solicitation of a child, which can either be actually electronically soliciting a child, or it can be basically communicating sexual stuff to a child, say emailing a child a sexual image or something like that. So that's all in the existing crime, and all that is ranked at severity level G, sex offender grade. Add to that, we have this new crime of grooming. So we got 3 crimes, 3 basically child solicitation crimes. To that, the legislature, in addition to adding grooming, is adding 2 more, I'll call them crimes, but they're also sort of like crime modifiers. They basically apply to all 3 crimes and extend them past children under the age of 16. So these next 2 crimes don't sort of adopt the elements of either of those first, if that makes sense, but then add special circumstances where these could apply to people over age 15. And those circumstances are: 1, if the person is in a current or recent position of authority over a child, more than 36 months older than the child, or I should say minor, because child is defined in the statute as 16, and the minor is age 16 or 17. So that's one, and this is really closely tracks criminal sexual conduct law, where a crime that normally would require the child to be under age 16 also applies to a 16 or 17-year-old if the person is in a current or recent position of authority over the child and is more than 36 months older than a child. The other crime that's created is basically taking one of those first 3 crimes, one of the first 3 solicitation crimes. If you count grooming as a solicitation crime, which I think you can, given the fact that the first element is essentially solicitation. So regardless of the child's, the victim's age, I should say, the victim could be an adult, as long as the victim is enrolled as a secondary school student, or I guess enrolled as a primary school student too, but I don't see how that's going to happen with an adult. But as long as the victim is an enrolled student and the perpetrator is a teacher at that school or a contractor at that school, then that's also a crime. So all those 3 child solicitation crimes also extend to them. So we're kind of taking this, and all those are under the same statute, 69352. We are recommending kind of the simplest thing, again, sort of this status quo bias here. We're just recommending to rank all 3 of the new crimes, so the grooming crime and the 2 new crimes that can apply to people over the age of 15, ranking all of those at severity level G. We also did a little offense renaming here, and that was basically because the 2 new crimes have to refer back to the 3 existing crimes. So we tried to give the 3 existing crimes a similar name so that the 2 new crimes could also use that name. So we're calling all of the crimes sexual solicitation. The first crime is sexual solicitation of a child. The next one is sexual solicitation of a child by grooming, sexual solicitation of a child electronic sexual solicitation of a child. And then we're adding to that sexual solicitation of a minor as opposed to a child, because it can be 16 or 17, while in a position of authority, and sexual solicitation of a student. So those are all the names of the crimes that I just previously described to you. Again, 2 of those are existing crimes. We're just changing the names so it fits into the new scheme with the minor and the student. Any questions or concerns about these recommendations or what we're doing here?
Can I ask a question?
And I just want to say, I know there's a wide degree of, legal training and experience with criminal law here. Please don't feel like you're not following. There's no shame in that. Please let me know and I'll try to explain it.
I just wanted to ask about the difference between the recommendation. Well, I mean, so I know that the grooming offenses, let's see, they are most like the solicitation offenses, which are on the sex offender grid, which is why you're recommending that we rank it on the sex offender grid, right? But then I noticed in the first offense, we talked about the coercion by threat to disseminate private sexual images. In the fiscal impact section, the staff assumed the case would be prosecuted federally, which is consistent with my experience when I was a federal public defender. A lot of these cases, or cases that seem to fit this fact pattern, would start out as like catfishing type situations for teenage boys using an avatar of a young woman to get the images. And then the person would basically then extort the production of child pornography created by the victim, which is why I would assume they'd be prosecuted federally. But I see you noted it was international perpetrators. But I guess the point of my question is that a reason to consider putting this on the sex offender grid, given that it would seem to me that the typical profile that might fit this, maybe it is a pecuniary gain, or maybe it's like another child at the school that's bullying, cyberbullying, someone else that might come up. But if it's a extortion and the gain that's being gotten out of the extortion is the production of child pornography, it would seem to me that might fit better on the sex offender grid.
The concern we have with that is, let's see.
And there may be good reasons not to do that I'm not aware of, or I could be misunderstanding what the common fact pattern might be for this.
No, I think you've got the fact pattern down. I'm just wondering if I don't remember off the top of my head Bill, do you know what the ranking is for private sexual images, the private sexual images crime? Okay, here it is. So it's non-consensual dissemination. So it's ranked at severity level 3. So it would seem anomalous to me, I guess, from a status quo bias again. It would seem anomalous to me if the crime of non-consensual dissemination of private sexual images would be ranked on the standard grid, but the crime of threatening to disseminate non-consensual sexual images would be ranked on the sex offender grid. That's not to say that the crime of that both offenses shouldn't be ranked on the standard grid, but one of those offenses is not before us because the legislature did not make any changes to the crime of non-consensual dissemination of private sexual images. So I guess that would be my jerk response to that.
That makes
Pretty good
sense. It just seems to me like the motivation for a lot of these crimes isn't actually to disseminate, it's to get more production of the images. If I understand the common profile, and maybe I'm wrong about that.
I think the motivation is probably money. I think that it's usually under the fact pattern that you just described. I think they're trying to extort the kid. They're not trying to somehow make money off of selling the child pornography. I don't know that it's intended to disseminate the child pornography. I think the child pornography dissemination is just a threat to get money. But I may misunderstand the fact that I've never had a case like this myself.
Thank you.
Any other questions about sexual solicitation of a child? The grooming, position of authority, and student additions to that. Right. Moving on then to item 4. This is probably the simplest item. So it's, I think this, you know, almost like so many times, this comes from a real case where it wasn't that emergency room personnel specifically who was, right now, emergency medical personnel are covered by 4th degree assault. 4th degree assault essentially has a group of people, and I'd be hard pressed to say exactly what they all have in common, but it seems like they're all kind of engaged on the front lines of first response, I guess, to difficult situations like police and so forth. That's not entirely true. I think there's also some transit workers and so forth, but that's most of what 4th degree assault. There's also a 4th degree assault involving bias. So that's essentially the other class of 4th degree assault. But so this is expanding to the protections that currently exist for firefighters and emergency personnel to extend to security officers who are providing services in a hospital or clinic. It makes it a felony with a 3-year stat max if the assault inflicts demonstrable bodily harm. Again, that unique standard that specifically applies to 4th degree assault. So bodily harm doesn't get you there. It's got to be essentially bodily harm that somebody else can perceive. And then that would be what you'd be ranking as new offense. The commission did recently upgrade the offense from severity level 1 to severity level 3. That will take effect August 1st, 2026, because the legislature did not take any action to stop that, and there's no talk about a special session that might do something different. So looks like that's going to happen on August 1st. Therefore, our recommendation is to also rank this at severity level 3, so that it'll be consistent with the felony assault 4th degree offenses. Any questions about that? And as far as the name goes, we're just crossing off emergency medical personnel. Okay, no other questions. The next one is theft from vulnerable adults. That's one of the ones you were going to.
Yeah, now you go to B.
Go to B. Thank you for that guidance. I wasn't really sure. So B is, we're calling this a conforming change. Usually we have some conforming changes, you know, where basically the law changes and the statute just has to update to that. This actually could be in section A. It's not an automatic conforming change. It does require some discretion on the part of the commission. So the law does 2 things. It changes this odd list in 244.10 subdivision 5A. So what the legislature did in 2009, I'm not exactly sure what, maybe somebody here does know, but the legislature essentially made a carbon copy of the sentencing guidelines aggravating factors. It put them in statute 244.10 subdivision 5A. And I mean, that might have made sense a few years earlier, shortly after the Supreme Court case called Blakely, which I write about. You can read about if you have more interest in that. After that decision was made, there was kind of this state of uncertainty as to how Minnesota sentencing was going to work in the future and whether there was going to have to be some new process for aggravating factors. And so the legislature in 2005, very quickly after Blakely versus Washington was decided, filled the void or tried to fill the void by enacting subdivisions 4 through 7 of 244.10. Then the Supreme Court adopted rules of procedure that basically superseded that statute. But then in 2009, the legislature enacts 5A, which mirrors the sentencing guidelines list of aggravating factors. And we kind of ignore that list, to be honest. I mean, I don't know if anybody actually follows that list. The guidelines still have their list of aggravating factors, and that's what we refer to when we're talking about aggravating factors. And then you have the statutory list of aggravating factors. I guess both lists claim to be non-exclusive, so maybe it doesn't really matter that there's this statutory list and the guidelines list, because either one is claiming to be the be-all and end-all of aggravating factors. But be that as it may, this list hasn't changed in a while, but the law adds to it a new aggravating factor of age deception, which is basically impersonating a minor in order to facilitate a crime against a minor victim. And I think this has something to do with an adult who tended to be a high school student and maybe engaged in misconduct. I'm not really sure, but they were thinking, well, if you're pretending to be a minor, you basically get access to the minor. Pretending to be a minor, that sounds like an aggravating factor. Then the law also enacts 609099, which is a new statute, which has the same standard, right? This age deception, impersonating a minor to facilitate a crime against a minor victim. But it doesn't say the judge can depart from the sentencing guidelines under 609099. It just says the judge can consider as a relevant factor whether an adult offender intentionally deceived a minor victim. So yeah, the whole standard is an adult offender intentionally deceived a minor victim into believing the offender was also a minor in order to facilitate the commission of the crime, which I tried to write in a less wordy manner in the sentencing guidelines. So our recommendation is basically, it sounds to us like the legislature is strongly suggesting that the commission add this as an aggravating factor to the sentencing guidelines. So the way it's worded is, we don't have the intro here, but basically the intro is this: the following is a non-exclusive list of aggravating factors, and it says the offense committed against a minor was facilitated by impersonating a minor in the manner described in Minnesota Statute 609, with the new statute there. And we don't reference the other version because I guess honestly I don't want to dignify the other version with mention in the sentencing guidelines. Right now the sentencing guidelines are kind of ignoring 24410 point subdivision 5A. I kind of like to keep it that way. So we reference the version that's in 609.09. Any questions or concerned about how we've done that?
Commissioner Fraze, did you have a comment?
Yeah, well, I mean, it's a comment about the 2009 list, but it might relate to the decision we're about to make. I don't remember noticing that in statutory factors, but it seems to me that as a matter of fair notice, people should know as much as they can in advance before they act, not only what's criminal, but how criminal it is. You don't have to tell them in advance that here are the mitigating factors, but I think arguably you should tell them in advance what the aggravating factors are and keep the list current guidelines. So yes, and also the leaner language. I mean, I like lean language, but the statutory language, I mean, in quotes here on page 25 isn't that long. And again, it tells people this is what you could get more for.
Yeah. I mean, part of it is we're trying to avoid using the word offender in the sentencing guidelines. We're trying to use personal language first. And so this is focusing on the offense, which number, it's in between 13 and 15, and those both focus on the offense. I think the word impersonating, I would argue, captures the concept of intentionally deceiving someone into believing that there's somebody they're not. I mean, saying somebody's an adult offender, I think it's implied if you're impersonating a minor, you are by definition an adult, because a minor does not impersonate a minor. A minor is a minor. So
yeah, I mean, it's good enough.
I think think we captured the gravamen of the offense, but I think it's both belt and suspenders. We are referencing the statute that has the full language, which is not unprecedented in the aggravating factors. There are other aggravating factors that reference 609 and 1095, for example. But yeah, if it's the will of the commission to just quote the statute as it is, we can do that.
I mean, number one, I appreciate that you cited to the actual statutory provision where the legislature is saying the court can consider this, because having been the staff attorney to the Criminal Rules Committee when all this went down, the court, the legislature acted, they filled a void. Like you said, there was no procedure in place for the courts when Blakely changed very quickly, and the legislature did that very quickly. But with the Supreme Court having since acted and put those rules in place, those do take precedence, and the statute will lose in a battle every time with that because that's their purview. So I also don't want to give credence to the statute. I think which is why I really like the way that you did it, by sort of saying, okay, well, they've given a statute to the court saying you can think about this in sentencing, so it would make sense to provide guidance in an aggravating factor, but not actually acknowledging that list that's there that doesn't need to be there anymore. That's my take.
And I do recall Judge Warnick, who I guess only one member of the commission was a member with, but earlier in my tenure advocated for recommending that the legislature repeal 24410 subdivision 5A, because he viewed it as being an infringement on the commission's role to determine what the aggravating factor, or to I guess come up with a non-inclusive list of aggravating factors.
I agree.
But I don't know whether it is an infringement on the commission's role or not, but that's what Judge believed, and I am sensitive to the whole idea that pretty much everything in 24410, starting with subdivision 4 on, is sort of in some way getting in someone else's space, I guess.
Oh, Commissioner Ede.
I was just gonna add, I mean, if the animating, I guess, principle that's underlying making this change is the statute itself, and the commission wasn't otherwise considering adding this to the list of aggravating factors, I just wonder if it makes sense to use slightly different language in the aggravating factor, acknowledging what you just said, just because I can just see litigation about, is impersonating the same thing as intentionally deceiving, which is what the language, and every district court judge now is going to have to refer to the language in the guidelines and then go to the statute and try to reconcile both of them. And there's going to be a lot of appellate litigation about whether both of those have been met. And maybe that's okay, and that's by design, but it's not the exact same language. And I can see very good colorable arguments that intentionally deceiving a minor victim into believing the offender is also a minor might not be the same thing as impersonating a minor. And so, I don't know, are we introducing an unnecessary layer of uncertainty by not just using the language as Professor Frace was suggesting? So
if we went to 609.099 and mirror the language there, except I don't like that they put the word offender in there.
but I mean, you could just say the offense was committed by an adult who intentionally deceived a minor victim into believing the adult was also a minor in order to facilitate the commission of the offense, and then you're not using the word offender at all.
Mm-hmm.
I mean, if that's the big concern, I don't know. I mean, I'm sure you're going to get the departure reports that are referring to both this and the statute.
Yeah. we could do that.
What about starting with the commission of the offense? The commission of the offense was facilitated by adults intentionally deceiving. I mean, because you're gonna say the offense twice, then
Oh,
if you do
sure.
it that way, but if you start with saying the commission of the offense was facilitated by an adult intentionally deceiving a minor victim into believing the adult was also a minor. Does that work?
The word offender appears in none.
It
Madam Chair?
does. That's one of the things we're hoping to change in the restructuring, but
Commissioner Ladd.
Thank you. I would agree with Judge Eads' comments that he stated, and I'm looking at the language from 609.099, and it's not complicated and it's not comprehensive. I don't know why we would not use that language, omitting the word offender. It's very short, and so I guess I'm not seeing why we're trying to sort of wordsmith something that's already laid out, and it would eliminate, I think, some arguments that might find themselves sort of in an appellate situation, and that's what we want to try to avoid as well.
Yeah, I think Nate, we just take it from an adult intentionally deceived a minor victim. From that part forward.
and replace adult, the second offender with adult.
And so replace the second offender with adult in order to facilitate the commission of the crime.
Just share screen here.
I mean, offender appears in the guidelines currently 397 times.
And it's because we haven't done like a
So I don't know. that we-
comprehensive,
Restructure's getting rid of
We're
it.
yeah, it is.
Okay, sorry.
But we're trying not to make it, we're not trying not to add to it as we go.
Got
And
it.
then he's doing that sort of.
So this is,
Right.
this is what I've got. This is statutorily the same, except I've omitted the word offender after the first adult, and I've replaced the second offender with the word.
Yep. I think that's it.
We take a motion on that. Madam Chair, since that's a change, we'll be able to do that smoothly.
Okay. So then we would need a motion to, hang on, I lost my materials. Okay.
And just for shorthand on motions. You don't need to say, preliminarily approve, subject to a public hearing, effective August 1st. That's all assumed. So just say,
I make the motion to adopt the proposed language that's on the screen.
Second.
All right, Commissioner Ladd makes the motion, Commissioner Reeves seconds. Any discussion on the motion while Nate is taking that down? Commissioner Moore?
I share the concerns expressed by Judge Ead and Commissioner Ladd, and I think others. I think this is a better, just a better way of addressing this particular issue.
Sounds good.
and just to be clear, no statutory reference. So it's just,
Oh,
which is not really necessary given that it pretty much quotes the statute. So.
what do you all think of that? The original way that he drafted it included a reference to the statute. Do we want to keep that in there? I don't know why I keep losing this.
As it relates to my motion, I would not be opposed if we wanted to say at the end of that, as described, and then plunk in the statutory reference. I don't know if that's duplicative or not, but I think with the language change, we're saying what the statute already is.
What do y'all think? Should we add the as described in 609.099?
It looks like there's a few other, I'm just looking through the aggravating factors, places where their statutes reference as defined by. I don't think it would make it an outlier. It might be a nice historical marker of why it came about.
Okay, so how would we put that in Nate so that we get friendly amendments to that effect?
Yeah, so the motion is to adopt, quote, an adult intentionally deceived a minor victim into believing the adult was also a minor in order to facilitate the commission of the offense in the manner described, so the statute 609,
Can you just say as described in
Sure.
Midstat 609.09?
as described in Minnesota statute 609.099.
And I would make that a friendly amendment to my motion.
Okay, so that the motion is that. Now Commissioner Middlebrook had a comment.
Thank you, Madam Chair. Just a question I had on wordsmithing. Does that language that's up on the screen, does it sort of mirror the other aggravating factors, how they're written, or do we need to wordsmith it a little bit differently?
I mean, it was, that was how I wrote it to kind of fit into the neighborhood, but I mean, it certainly is, I think, an aggravating factor. I don't think there's any way to construe it as an aggravating factor.
You had Commissioner Eid, I know you have the factors up. Like, does it generally fit?
Does it flow with the other factors?
Yeah, so like there's a few of them that start with the offender or an accomplice knowingly possessed a firearm other than a dangerous or other dangerous weapon. There's some that start with the victim as the focus, right? I think it's a great point, because we don't tell the reader right away that the adult that we're talking about is the person whose sentence is going to be enhanced by application of this factor. So but I think and the rest, some of them are in full sentences. That's not really,
So there's no format,
guess
is
that
what
is a
you're saying.
There isn't a consistent. I was looking at these three that he listed here. That's what I was trying to think.
I think the new format, to be consistent with the new format, I would say something like the person being sentenced
Is an adult.
is an adult who intentionally.
was an adult who, because now it's past tense, because the present tense is the sentencing moment. The person being sentenced was an adult who intentionally deceived a minor victim. The adult was also a minor. I think that's sort of restructuring the format.
I would go with the offender was an adult.
Yeah, we're trying to get that out of the guidelines. The word offender. Commissioner Fraze.
Since we do have all these provisions that do say the offender, and we just keep that in there for now, and at some point, we're going to address this more stylistic thing about not saying the offender, but just kick this can down the road along with all the others that waiting to be kicked, apparently.
We've been trying not to do that anywhere else. Probably just a year out, I hope.
Yeah, we're working on it. I have been trying to, I'll just disclose one of the other things I'm trying to do, like when we have offense names, is have an offense name that fits in the blank to say, Professor Fraze, you are charged with the crime, and then it would fit in that blank. Because not all of our offense names do that. Some of them are just, they don't really say a crime. So we're trying to do that, for example, and we've been trying to do that as we go along, essentially. So one of the things we've been trying to do as we go along is get rid of. Yeah, we could. If you want to kick the can down the road, here's the statutory language. And it's belt and suspenders because it also says as described.
Yeah, it's not a hill I'm going to die on because we have too many things to get to today.
True.
So Kyra, Commissioner Ladd and Commissioner Reeves.
Yes, I'll
Are
make
you
another
all
friendly
set?
amendment to my motion.
Okay, thank you. Commissioner Reeves, you're good?
Yes.
Okay, all right. I think we're good. Let's go ahead and vote on this unless there's any other comments. Let's vote on it.
So to the Ladd motion to adopt as a new aggravating factor at guidelines 2D, 3D, 14. An adult offender intentionally deceived a minor victim into believing the offender was also a minor in order to facilitate the commission of the offense as described in Minnesota statute section 609.099 and renumber the existing 2D, 3B, 14 as 15. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Ede?
Yes.
Yes. Phrase?
Yes.
Phrase, yes. Keith?
Yes.
Yes. Ladd?
Yes.
Ladd, yes. Mazzaros? Mazzaros absent. Moore?
Yes.
Yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes opposed.
With that, the motion is approved unanimously. So now let's go back to items 1, 3, and 4. How are folks feeling about those? One, if the staff recommendation looks appropriate on those items, one potential motion is to adopt those items as staff recommended. But if there's anything that anyone would like to offer an alternative, we can pull that one out and vote on it separately and discuss it separately. Commissioner Saxena.
Thank you. I just had a question about item number 1, which was the coercion by threat to disseminate private sexual images. So, and my understanding is that the staff recommendation is to rank the 2 subsections that involve potential great bodily harm as a 9, and I think the other one was an 8.
No, death is a 9. Great bodily harm is an 8.
I'm sorry. Yes. So I guess my question is about this, the new language in the amended statute, substantial factor. No question, this is a very heinous crime. I just searched the statutes and I don't see that term substantial factor being used in other statutes. It gives me some pause because the other crimes that I'm aware of that involve great bodily harm or death, they have a very clear standard of causation, like that the offense caused great bodily harm or death. And I'm a little confused about what substantial factor means. I think it's, as far as I understand it, it is a civil concept of like proximate causation, and it is not like a very well-defined criminal concept of causation. And so, and I understand the sort of example that Director Wrights gave of someone committing suicide after such an offense is committed. To me, that's very different from most other crimes where great bodily harm or death results, because it's not the intended it's not necessarily the intended or foreseeable result of the defendant's conduct. So I guess, I'm sorry to ramble on for so long, but I've just been kind of sitting here with that. I wanted to make that point and see if anyone can help explain why this isn't different from those other types of offenses.
Go ahead,
Just make a comment. You recall recently we did the ranking exercise on offenses resulting in death. And you may recall that there were 2 chapters to that. Chapter 1 was there was some kind of mental state with respect to the death, whether it was intentional or reckless or whatever it was. And then as a result of that, somebody died. And then chapter 2 is basically you did something wrong, and then as a result of doing something wrong, somebody died. And I guess I thought of that as being in this category. But you're right, it doesn't say as resulted in death. Like there's I'm looking at the swatting crime. It says that somebody commits a swatting crime, and the call triggers an emergency response, and as a result of the response, somebody suffers great bodily harm or death. So I think resulting in or as a result of is a little more conventional language for these crimes. You're being told from a legislative staffer that you are correct, that that's a civil standard.
Yeah, and I guess
It's now criminal,
I guess I would be a little bit concerned about the suicide example that you gave, Director Wrights, because I don't know if that's what the legislature was thinking, but obviously these are very weighty topics, so I hope I'm not coming across as callous on any of this, but obviously there's a lot of factors that go into something like that, and it just seems like a very high severity level where the conduct itself did not directly result in the injury or death, to me.
Commissioner Fraze.
Well, I agree there's a problem with the statute not defining substantial factor. It would have been better, I think, if the legislature had used the language of third-degree murder by drugs, which uses the word proximate. The courts are obviously going to have to decide what substantial factor means, but I wouldn't be surprised if they say, well, essentially it's proximate cause, just like third-degree murder. So, which is ranked at level 9. So I think that's where it belongs, for now anyway.
Any other discussion on that one? Is that one, Commissioner Saxena, is that one that you'd like us to pull out and vote on separately, or? What are you thinking there?
No, I appreciate Commissioner Fraze's comment. I think it's a little bit vague, frankly, what this means. And so, I'm going to go along, I think, with what Commissioner Fraze just said. And I don't know what the right procedure is to, approve this, but I guess it just gives me some concern that it could be used for sort of extreme situations that may not involve the normal concept of causation in a criminal offense.
I appreciate you raising that. There's a lot of interesting language in the statutes in front of us today, I think. All right. If the question would be, is it the will of the commission to follow staff recommendations for numbers 1, 3, and 4? Or if so, then I would ask someone to make that motion. Otherwise, if somebody has a different idea for any of it, we should take that up.
Can I ask a question?
Yes,
about the
Commissioner
4th degree assault? So my only concern about that, and if I'm remembering correctly, this might have been a concern with the last year's session, is that particularly for, obviously it's a serious crime of assault on a hospital security, but I guess one of my concerns is that most of the cases that we're going to see sentenced under the amendment are going to be in our safety net hospitals involving people that are profoundly mentally ill and are seeking under mental health crisis. And so I only raise that because there's obviously a difference between that and like someone who intentionally in their right mind attacks a security guard while they just happen to be at a hospital. The mens rea is completely different there. But I'm wondering, is there a place in the guidelines for commentary reminding judges of the existing mitigating factor regarding, you know, I can't remember the exact language. I was looking at it earlier of mental impairment, lacking substantial capacity for judgment when the offense was committed, because it seems to me there may be a lot of those offenses and that may not belong in the higher severity level that will fit that profile. And maybe I'm wrong about that, but it just, from my experience anecdotally, that seems like that's the case. So I wanted to ask about, I don't necessarily have an opposition to the severity level recommendation, but whether or not there's a place in the process for a comment, something along those lines.
Yeah, before I take other comments, Director Wrights, what is the process if we want to add comments to any of these things?
If you want to add a comment to the sentencing guidelines.
Yeah, I mean, that's along those lines, like if someone were to put that forward, like what would the process be? I mean, right now we're in this weird space where we have to go to public hearing next week, so, or next month.
Well, not sure where that would go. So I don't know if that would go under, it'd be interesting because right now there aren't, I guess there are some comments. B3. You're thinking of putting a comment into.
Just procedurally, how would you want to deal with that? And when, because it would have to be written and all of that stuff. So just procedurally, what is the process for the commission?
There is some precedent for comments not going to public hearing because they're not part of the sentencing guidelines. So in theory, but if that were, it would, I mean, it would fall under the first reading rule, but I guess we discussed it at this meeting. So if somebody were to bring it up at the July meeting and the commission were to agree to it at that time, a comment under 2D3, it would have to be given to the commission 7 days in advance, I believe, the text of the motion. But if that were done, then I think the commission could adopt it, change to the commentary at the July, not the July public hearing, the July meeting. That's 1 week after the public.
Okay, so that's the process. I just want to make sure that process is out there. Commissioner Ladd.
Thank you. I just wanted to comment on Judge Eads' concerns. I think we probably had some of these discussions when we were discussing these similar issues last year. And I think not that the comments would be not relevant, but we probably wouldn't even get there because a lot of these kinds of cases find themselves under a Rule 20 process related to whether or not someone, whether it's 2001 or 2002. And so it doesn't, that's kind of where that gets addressed and sort of how those sort of decisions are made about sort of someone's capacity and what they're doing or not doing related to their intent of committing whatever act it is. And obviously we see a lot of those, and there's a lot of work being done also on that Rule 20 process as well. So I think that sort of satisfies some of those concerns because that's where a lot of that stuff gets sort of flushed out and addressed as to whether or not someone's ability to understand either what they're doing or appreciate the criminal conduct or circumstances they find themselves are in. That side process is really what sort of takes priority in those kinds of cases.
All right, any other comments? Commissioner Castro.
You know, I appreciate Judge Eads' comments on that, but I also realize that they apply in a variety of other situations. You know, this is the 4th degree that has been charged out in jails for years. And so that issue should generally come up as a mitigating factor if the person pleads guilty. I don't know where else we would be able to place that, because I would imagine that there are multiple places that we can point out that particular mitigating factor, which would be relevant in a variety of scenarios throughout the guidelines.
Commissioner Mueller?
Not to reiterate what's already been said, and I agree with that, and I would just hesitate to add commentary either on mitigating or aggravating factors. That's really hesitant commentary and where that come from, even though I absolutely agree with your perspective on how to charge this out, but I think it would be captured in the process. Commissioner Ladd mentioned.
I think that now I'm editorializing, but I do think that I agree with you that there are some of these charges occur when the person has mental illness or when other things are at play, and I do think there could be more restraint across the system in when these charges occur. So I agree with you. And I'm not making a comment either way about whether we should have a comment in the guidelines today, but I'd certainly be willing to look at one, but I don't think that given what we know about the process, we don't have to decide that today. This is more about where do we want this particular offense to be ranked today. So, all right. So,
Sorry,
Commissioner Sextina.
I'm sorry to belabor this, but with this idea of with this idea of a comment, and I don't know if anyone else would be on board with a comment on the substantial factor language that's consistent with what Commissioner Frey said, that it should be interpreted in the same way as it is in the third-degree murder statute. Do I need to mention that today for purposes of keeping it alive for the next meeting? And if
Yes,
so,
I do think that would be, yes.
Okay. Can we consider it mentioned for purposes of keeping it in play?
Yes. It has.
Thank you.
So noted. So noted.
All right. Thank you.
Commissioner Castro, do you have your hand up again, or is it just still up from before?
It might still be up. There you go.
Okay.
Thank you.
Commissioner Keith.
Under the mitigating factors, one of the things that I saw is it was put on the screen was if the victim was the primary aggressor. I'm curious whether there's any clarification around whether that's like physical, verbal, if all of that is included.
I think I'm not understanding the question.
Yeah, so I feel like most often when we're considering aggression, it's that we're looking at whether there was a physical altercation. And I'm curious about whether being like verbally attacked by somebody that might then result in a physical attack would be, if somebody was to verbally attack someone, whether that would be considered aggressive. And part of my thinking about this is, given the state of the universe, I feel like racial comments are things that are coming up much more frequently. And going to some of the other commissioners' comments around folks struggling with mental health issues, that could be a big trigger and could result in them physically harming someone that works at one of these hospital settings. And I was curious whether that would be considered aggression from the victim. Is that making sense?
I think so, because Commissioner Castro raised his hand to answer that one.
All right, great. Thank you.
I think the answer to your question is yes. I think what that particular mitigating factor goes to is you don't have a self-defense claim, but you had something that triggered you to react the way you did. So I would say that yes, when someone attacks you verbally and then you respond, you might respond inappropriately, but you weren't the initial aggressor. I mean, that would be a circumstance that certainly I would consider.
Thank you.
Okay, so I think we're back to, is there a motion relating to items 1, 3, and 4 on the list today?
So moved
What is the motion?
to approve the language given 1, 3, and 4. Do I have to say it all?
That's
Okay.
adopt the staff, you got it? Adopt the staff recommendation.
Staff recommendation, yes.
Okay, is there a second? Commissioner Fraze, okay, so Commissioner Reeves makes the motion, Commissioner Fraze seconds. Any discussion on that motion? We're all discussed out. All right, we'll go ahead and vote then, thank you.
Reeves' motion to adopt staff recommendations in items A1, A3, and A4 in the staff paper called possible modifications to the sentencing guidelines dated May 26th. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Eid, yes. Fraze? Fraze, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazaros? Mazaros absent. Moore?
Yes.
Moore, yes. Morin?
Yes.
Morin, yes. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 12 votes in favor, no votes.
Okay, with that, the motion is approved unanimously. Then we'll go to item 2, and from here on out, I mean, I thought the other ones were easier than these, but maybe not. But here on out, we'll take each one, so we'll vote on each one as we go. Because these are much more, have more tentacles to them.
Yeah, so I think this is actually the most interesting crime, just from, or the most interesting change. So they take, there's existing crimes that they aggravate, and then they add a couple of new crimes, basically. So they take the misdemeanor crime right now, which is falsely impersonating a peace officer, and they make it, I guess, a minor felony. So it's a 2-year, $4,000 statutory maximum. It's not as low as it can go, but it's pretty low felony there for falsely impersonating a peace officer with the intent to mislead another into believing that the impersonator is actually an officer. So this shouldn't cover a Halloween costume or something like that. You're not actually trying to fool anybody into thinking an officer. So that's increased from a misdemeanor to a felony. Then we have the existing felonies, which are increased to more severe felonies. So I'm sorry, the next one is a gross misdemeanor. So this was a gross misdemeanor where you're getting the base offense, falsely impersonating a peace officer with intent to mislead, and then you're either I would call it exercising authority. You can do that by accessing a public building or government building that's not open to the public due to your apparent authority as a police officer, or you're issuing somebody an order that they would presumably have to obey if you were in fact a real police officer. So that's 1 and 2, and then 3 and 4 have to do with vehicles, using a restricted vehicle light or siren, or operating a vehicle that's either marked as a law enforcement. And then there's some new stuff here with respect to vehicles that wasn't in the pre-existing gross misdemeanor. And that's just basically displaying equipment that's commonly attached to law enforcement vehicles. So it looks like a law enforcement vehicle, basically, or and I'm not sure what they had in mind there. If they meant like a light bar, or exactly what they meant, but something that makes it look like it's a law enforcement vehicle, short of being marked as a police vehicle. I don't know, Chief, if you have any insight on what kind of equipment or facsimile of equipment that would be.
Yeah, they're talking about, radios inside the vehicle, the spotlights on the vehicle. So we actually have a responsibility now when we sell these vehicles to strip the vehicles of all of that kind of equipment. So they're looking at all that, light bars, gauges, spotlights, any of those things would count.
I had a friend who bought an old police vehicle. We used to love playing around with the spotlight. All right, so that's the gross misdemeanor that's now enhanced to a felony, a 5-year, $10,000 felony. So that's sort of the normal default felony penalty. And then there's an existing crime in subdivision 3, which is now numbered as subdivision 3A, which is repeat offense. So you violate anything in this statute within 5 years of a previous violation. That would be increased from that low level felony that we saw before, the 2-year, $4,000 felony, to 10 years or $20,000. So much more significant felony. Now keep that 2-year, $4,000 in mind though, because that's kind of when we were thinking how we'd rank this, that was sort of our a key piece of data there. That is the stat max that is now assigned to what was a misdemeanor. That makes sense. So, and then there's a new part of subdivision 3, which is possessing firearms. So if you commit, if you impersonate a peace officer while you're possessing a firearm, that also has this much higher felony, 10 years, $20,000. And that, interestingly enough, was not in the statute before. So it seems like probably a good idea to have been in there. And then finally, we have an enhanced penalty. So this is probably the biggest challenge to you as far as ranking. And there's really 2 parts to this. So one is it enhances misdemeanors to gross misdemeanors. So any misdemeanor, right? Pick your misdemeanor. If you commit a misdemeanor while you're falsely impersonating a peace officer with intent to mislead, it becomes a gross misdemeanor. If you commit any gross misdemeanor while falsely impersonating a peace officer with intent to mislead, it becomes a felony with a 3-year, $15,000 stat max. And then this is the hard part for you. If it's a felony already, so pick your felony. It could be anything from I don't know, fleeing a peace officer. I don't know if that makes sense, or murder, or whatever it is. If the crime is a felony, the stat max goes up by 5 years. And you can still get prosecuted for the felony, or you can still get prosecuted, I should say, for the impersonating peace officer. So that's subdivision 4. So that's the challenging thing. Ostensibly, there aren't any issues for you in subdivision 5, although I will say that there's sort of this hidden crime lurking in subdivision 5. So subdivision 5 requires basically peace officers to identify themselves upon demand. Or just while they're walking around, they basically have to either have their last name, badge number, and the entity that they work for on their uniform, or if somebody asks them for it, they have to tell them it or present a business card that has that on it. There's exceptions for SWAT. SWAT doesn't have to have their last names on their uniform. And undercover officers are obviously victims. They're actually arresting somebody. So, but here's the thing: is subdivision 5 contains no criminal penalties, but it does have requirements in it, right? And if you go roll back up to subdivision 3B, that new subdivision for possessing a firearm, if you violate the statute, right, while you're possessing a firearm, that's a 10-year, $20,000 stat max. So I think, and this may not have been, probably wasn't the intent of the legislature here, but it seems like if you violate subdivision 5, that is, you violate the identification requirements of subdivision 5, and you're carrying a firearm, which I'm assuming most peace officers are. Subdivision 5 isn't about impersonation; it's about real peace officers. And you're carrying a firearm, you're looking at a 10-year, $20,000 felony, which is, again, may not have been the intent. I'm not suggesting that you rank subdivision 3B based on that, but it's something that I feel like you should know as you're going through the ranking process. So our recommendation is to rank the base offense at severity level 2. That's because the existing offense that has that 2-year stat max is ranked at severity level 2. That's the one with the 2-year statutory maximum. We're recommending ranking impersonating a peace officer, intent to mislead buildings and vehicles. That's the one where the stat max goes from a gross misdemeanor to a 5-year felony. Recommending ranking that as severity level 4. So a lot of decisions here. Next one, re-ranking impersonating a peace officer with a previous violation at severity level 5. And the new one, so that's because the stat max goes up to 10 years. So that's the one that's currently at a 2. It's the only felony that's currently ranked in this provision. Currently at a 2, we're recommending going that up to a 5. Reasonable minds may disagree on all this stuff. Rank impersonation of a peace officer, same stat max, 10 years, but we're recommending ranking this at a 6, just because that's where possession of a firearm or ammunition after a crime of violence is ranked. But that does have a higher stat max. So, you could keep both of those subdivision 3 offenses at severity level 5. And then, so this is the tricky one. Ranking impersonating a peace officer when it applies to another crime. So the first one is, what we're recommending is that you rank the gross misdemeanor that turns into a felony at a static severity level 2. It's got a 3-year stat max, severity level 2 fits for that. Could go higher, could go up to a severity level 3. And then, so here's the tricky one. So what do you do with the thing that adds 5 years to anything? Well, it sounds a lot to us like the gang fire. So under the gang statute does the same thing, right? It takes any offense. Oh, well, I should say the gang statute is limited to a finite number of offenses. This is unlimited. Any felony qualifies for this. But if you do one of the qualifying offenses for the benefit of a gang, stat max goes up by 5 years or 10 years if there's a minor. And what the commission has done with that is they've said, okay, we're going to take that 5 years increase in stat max, and we're going to convert that to a 12-month increase in the presumptive duration. So the presumptive duration goes up by 12 months under the gang modifier, and recommending basically following suit, adding 12 months to the presumptive duration. Now, the gang statute also turns it from a presumptive stay, if it is a presumptive stay, into a presumptive commit. But this statute doesn't do that. So we're only suggesting changing the duration, not the disposition, which the gang modifier also changes the disposition. So there are other ways to do that. There's with theft with creating a risk of bodily harm, which carries a 50% maximum penalty increase. The sentencing guidelines increase that severity level by 1. I will say theft, and we're going to get into this later because there's sort of another modifier they created with respect to theft from a vulnerable adult. But I would say the theft universe is a little bit different, where there's a finite number of crimes this could apply to. This one could apply to any felonies. I've said it several times. So I don't know if the 50% stat max increase makes sense. I'm sorry. I don't know if it makes sense to increase the severity level by 1 necessarily. I mean, I think that gets a little tricky, especially at the higher severity levels. Another approach that the commission has taken is increasing the duration by a percentage. So criminal sexual predatory conduct has a 25% stat max increase statutorily. The commission follows suit by increasing the guidelines duration by 25%. But we're because it looks so much like the crime for the benefit of the gang, we're recommending just the 12-month increase if it applies. So essentially, whatever the disposition is would stay the same, wouldn't change if it's committed while impersonating a peace officer, but the recommended duration would go up. So let's say somebody commits, I don't know, armed robbery while impersonating a peace officer. They'd be looking at a commit to prison for 12 months longer than they otherwise would, because of the fact that they're impersonating a peace officer. And then that would be cut in half if it's an attempt. So let's say we're an attempted murder while committing as a peace officer, it'd be a 6-month as we're recommending. So so that's this is the language pretty similar to the gang language. And it's kind of the new format that I'm going to be recommending. So any questions about, I guess, either any of the severity level rankings or about this new modifier that we're recommending?
Questions or comments? Commissioner Mueller?
I kind of appreciate that, the description on all of this, a lot of information for sure. I do like, when you're talking about the ranking of just the base, talking about the recommendations at 2, could go to 3. I would just recommend this is like that's where like the crime hasn't been committed, but that is the fundamental, legislative intent, obviously, of the tragedies from last summer. And so to really start that base level at 3 would be my recommendation.
Just check the grid on that. So it is a 2-year stat max, so 3 would just basically fit. The only thing that would be cut off would be the high end of the upper range at criminal history scores of 5 and 6. Those wouldn't be accessible, but it wouldn't be a terrible misfit if it were to be ranked at severity level 3.
Well, I mean, looking at it from that looking at it from that perspective, like the other ones seem a little low too. I'm just purely from the standpoint of at criminal history 6, are you approaching the statutory maximum? And I know that's not the end all be all, but ranking the intent to mislead buildings and vehicles subdivision 2 at 4, that has a stat max of 5 years. At 4, at 6, you're only getting to 36 months, Yeah,
and maybe I probably should have clarified what I was trying to say. So the commission has not, other than sex offenses, the commission has not historically made it a ranking priority to, hit the statutory maximum on it. But it does consider if it's going over. So if the stat max is so low that it doesn't fit on the grid, the commission has lowered the severity for some offenses below what it might otherwise have done. Makes sense. But it's not really a goal to try to hit the stat max, or at least historically it's not.
Did you have your hand up, Commissioner Rodenbach? Commissioner Rodenbach.
Thank you, Madam Chair. It seems like that the legislature's put the 2-year stat max on, which it seems like the other offenses in severity level 1 and 2 are at that same level. That I don't know that there's any that are in severity level 3 that have a stat max of 2 years. So they're indicating that fairly low severity level by that stat max. So it seems that the 2 fits there.
Something else I would just point out is presumably the legislature knew that the commission had ranked the existing 2-year offense at severity level 2. So, one could even, and maybe this is reading way too much into the statute, but one could read into that sort of a satisfaction with that ranking when it assigned the same 2-year stat max to subdivision 1. To basically say, okay, the commission ranked our other 2-year stat max at severity level 2, so it's okay if they rank this 2-year stat max at severity level 2. Again, that's may not have been the legislative intent at all, but that's at least one plausible interpretation.
Madam Chair, as a point of information, there is at least one offense that is at severity level 2 that is a stat max of 2 years.
What offense is that?
It's false imprisonment with just demonstrable bodily harm. 609.255 subdivision 3B.
Thanks. When I think what I'm struggling with is, I'm not necessarily, like, I don't have strong feelings one way or the other. I would be happy with the base offense being a 2. I could find my way to a 3, but then the other ones, it's like going too high if we push those up proportionally. So, I wouldn't want to change the other proposed rankings, I guess is what I'm saying.
Well, it is unusual, I think, for us to cover 2, 3, 4, 5, and 6.
Yeah.
It's, I don't think that was staff's intent, but.
Mm-hmm. Yeah, and so one of the other reasons, I guess, 2, or the base offense is at 2, is that the next one, you're committing another crime while you're impersonating a peace officer, which is more severe, and that's why that's at 3.
And it has a slightly higher staff max.
Mm-hmm. Yeah, I mean, I think it all fits the way that it's been proposed. Okay, so there's a number of proposals here. The way to get things started is for somebody to make a motion for what they're interested in. And you can take a piece or all of it, Commissioner.
To the extent that my comment earlier was considered a proposal, I'm not making any formal motion to bump up the other. I won't speak for Commissioner Mueller.
So, I mean, there's a few different ways to slice this. We could just take the ranking, do the modifier separately, or we could take it all together.
We can vote on a specific one if somebody wants to. Commissioner Castro?
I'm going to move that we take them all as recommended by the staff.
Including the modifier or just the rankings?
Including the modifier.
Okay, so we have a motion by Commissioner Castro. Do we have a second?
I will second.
Commissioner Eads seconds. Discussion on the motion. I'm sorry, Commissioner Middlebrook.
Go.
Thank you, Madam Chair. I've just got a question on the modifier. When it's if we went with the 12 months to the presumptive duration, does that also include these really low level state sentences that they would bump up to plus 12 months?
Yeah, and 12 months would get added to the range too.
It would only be duration, not change the disposition, right?
So that would be the big difference between this and the gang modifier. Well, plus the gang modifier is a double. It has a 10-year increase, which turns into a 24 increase if the victim is minor. So but it's basically sort of like a miniature version of the essence of the gang modifier.
Commissioner Castro, did you have another comment?
No, I keep on forgetting to drop my hand. I apologize for that.
That's okay. Commissioner Mueller.
Respecting Commissioner Castro's motion, either I'd like to make a second motion or a friendly amendment, just acknowledging the base crime to a severity level 3.
And that's a for some reason this body doesn't do that as a parliamentary procedure much, but that's a perfectly acceptable thing to do, is to make a motion to amend a motion. So what Chief Mueller has done is made a motion to amend Castro motion to And this is exactly the right time to do that during the discussion on the Castro motion to increase the ranking of the base offense of impersonating a peace officer to severity level 3. So what we would need then is a second to that motion.
Ladd seconds.
Okay, so that would, this is kind of exciting because this doesn't happen much in this body. So
Testing parliamentary procedure.
so now.
I'm glad you're excited, Nate.
It doesn't take much, Judge, but so now what would happen is there would be discussion on that motion, there'd be a vote on that motion, and then there'd be a vote on the original motion, which may be amended at that point.
Okay, wait a minute. Okay, so first of all, let me recognize that Commissioner Mueller made a motion to amend the motion, and Commissioner Ladd seconded that.
Discussion on the amended.
There's discussion now. Discussion on the amended motion. Commissioner Ladd.
Thank you. I wasn't going to make a motion earlier. I was just going to comment that if the motion went forward as it stood, I was going to vote against it, mostly because of that baseline offense being a 2, and I believe that it's appropriate at a 3. I know that we are getting, in terms of the stat max, we're kind of getting sort of, at the top of that. But given everything, I think that it's, in my mind, how everything else is fitting in here, I do think it's more appropriate at a 3, and that's what I would support. I support everything else as presented.
Okay, Commissioner Freitas.
Well, I guess I prefer the staff approach. I mean, of course, 2 reasons, I guess. One is that the base offense, falsely impersonating with intent to mislead another to believe the person is actually an officer, seems like it could cover a lot of situations that don't involve any of the aggravating factors under subdivision 2. So it's a little hard for me to imagine what the base offense is if it doesn't involve any of those factors. But the way the staff wrote this, we're saying instead of making 2 jumps up from subdivision 1 to subdivision 2. Well, no, I guess we are making 2 jumps up.
3.
Because where the statutory max is going from 2 years to 5 years. But I mean, it certainly makes a certain pattern to saying, well, 3, 4, 5, 6, each thing is one bump up. But I guess I'm a little uncomfortable with making, we have some sort of anecdotal information about what are the statutory maxes of the crimes that are currently in level 3 versus level 2. I don't have a good feel for that. Statutory max of 2 years that the legislature chose for this when they bumped it up from a misdemeanor seems pretty low.
Any other comments? I go back, I'll just put out there, I think that the more that I think about it, the other offense of committing a gross misdemeanor while impersonating a peace officer is the 1 jump up from 2. So I'm sort of leaning towards the original framework that that was recommended by staff. That's just how I'm seeing it. It does feel like each offense has more to it, but I can appreciate the position that you're coming from, Commissioner Mueller. All right, any other comments? Hearing none, I think we'll take a vote on the motion to amend the motion.
Great, so to the Mueller motion to amend the Castro motion to increase the severity or ranking of the base offense of impersonating a peace officer to 3. Middlebrook?
No.
Middlebrook? No. Castro?
No?
Castro, no. Eid,
No.
Eid, no. Phrase? No. Phrase, no. Keith?
No.
Keith, no. Ladd?
Yes.
Ladd, yes. Mazaros? Mazaros absent. Moore?
Yes.
Moore, yes. Moran?
Did we lose him? Might have lost him.
Warren? Warren absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
No.
Saxena, no. Mitchell?
No.
Mitchell, no. Sure, there are 4 votes in favor, 7 votes opposed.
With that, the motion fails. So does that put us back to voting on the original motion?
We'll continue discussion on the original.
Okay, is there any further discussion on the original motion? Hearing none, we'll go ahead and vote on that.
To the Castro motion to adopt the staff recommendations, item A2 of the staff paper called Possible Modifications to the Sentencing Guidelines and Commentary, dated May 28th, 2026. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Yes. Phrase? Frade, yes. Keith?
Yeah.
Keith, yes. Ladd?
No.
Ladd, no. Mazaros? Mazaros absent. Moore?
Yes.
Yes. Moran? Moran absent. Mueller?
No.
Mueller, no. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, 2 votes opposed.
And with that, the motion is approved. And I think we're moving on to item 5 when you're ready.
So, theft from vulnerable adults. This is another one where this could result in a modifier. Didn't do it that way. It's simpler to do it this way, but so essentially it's taking the existing crime of theft and increasing it in severity level. This is, it's kind of interesting that we were just looking at aggravated thefts in your ranking project and you may be influenced by whatever you were deciding in that project, this offense. But essentially the legislature is creating another form of aggravated theft. And if the offense is a misdemeanor or gross misdemeanor, so the last one was just gross misdemeanors enhanced to felonies. This one enhances misdemeanors or gross misdemeanor thefts. I'm sorry, misdemeanors are enhanced to gross misdemeanors. Gross misdemeanors are enhanced to 2-year felonies. And for felonies, the maximum sentence is increased by 25%. Let's see. So we're recommending basically having a severity level that's 1 severity level higher than just what a typical normal offense would be. So theft from a vulnerable adult over 35,000 would be ranked at severity level 7. Theft from a vulnerable adult over 5,000 would be ranked at severity level 5. And theft from a vulnerable adult at $5,000 or less would be ranked at severity level 4. And the new gross misdemeanor, theft from a vulnerable adult as to a felony, would be ranked at severity level 2. That matches up with the existing rankings for financial exploitation of a vulnerable adult over 35,000, 5,000, 5,000 or less, and the existing rankings for theft, misdemeanor gross misdemeanor theft with a reasonable risk of bodily harm. Another example, theft. So that's where we got that severity level 2 ranking. We talked a little bit about what financial exploitation of a vulnerable adult is here, so you can kind of compare it to theft. Okay, we assume kind of you understand what theft is, although there are a lot of different ways of committing theft. But one is a fiduciary who has special access to a vulnerable adult's property mismanages or misdirects that property. That don't necessarily need that same intent that you always have with theft. I think the intent is sort of supplied by the fact that you're a fiduciary. You had a responsibility to that vulnerable adult, basically you blew it. And then a vulnerable adult's financial resources are acquired through undue influence, harassment, or duress. So that's the existing crime of financial exploitation of a vulnerable adult. You know, I think it's kind of, I think some people could look at that and say, well, that's more serious than theft. And some people could look at that and say, well, that's less serious than theft. But theft, staff kind of saw it in pretty much the same ballpark as theft. And so thought it was appropriate to recommend ranking it the same. So financial exploitation of a vulnerable adult being ranked the same as theft from. So that's our recommendation. Then so this is kind of getting a jump start a little bit on the restructuring project, but since we had to change guideline section 2A2 anyway, is to renumber the statute number is changed. This is all about theft creating a risk of harm. There are just words in here that were excess, didn't need to be in there, just a lot of stuff that we thought we could clean up. And the reference in the head note to damage to property is just wrong. I don't know where that came from. My apologies to whoever put that in there, but I don't know why it references damage to property. There's no statutory damage to property creating a risk of harm that increases the maximum penalty. That's theft creating a risk of harm. So there's some extraneous changes to 2A2 in there that we didn't need to make. The only thing we really needed to make was to change the citation, but there it is. So here are the rankings in a nutshell. You've got theft from vulnerable adult. Here it is in a nutshell. So 7, 5, 4, and then 2. It was a misdemeanor. Any questions or discussions on that?
I'm going to make a comment that trying to understand this one almost made me want to fix all the rankings. You know that project you wanted to do?
Yeah.
This is the one that made me go, oh, now I get it. It's a mess. It was really, really complicated. The thing that I'll just say that's sort of hitting wrong with me, but I could not think of a better way to do it, is this, the modifier for risk of harm, you know, theft resulting in a risk of harm. That increases the felony penalty by 50%, increases the stat max by 50%. For this one, theft from a vulnerable adult, it only increases it by 25%, but the approach is the same for both, of adding a severity level. And so that, like, it didn't feel equivalent, but I could not think of a good way to do it either. So I just felt like I had a voice that I was a little frustrated in trying to figure it out. I finally just got to a point where I think I accepted the way that you went, because I couldn't think of a better way to do it, but it didn't feel equivalent to me. I mean, it didn't feel, the legislature sending different signals there, for better or worse. Although I do think that theft from a vulnerable adult is a very serious offense.
Yeah, and in practice, we just don't see much,
Mhm.
theft resulting in harm. I'm not,
I don't even know how you commit that.
I don't know
was
how you
actually-
could either, honestly.
I would love for a prosecutor to explain that one to me.
Maybe if you stole like a railroad tie or something and, I don't know. Something like that. I don't know.
Yeah, I suppose that would create a risk of harm. Yeah. All right, any questions, comments? How are people feeling on this one? Does anyone want to bring a motion on this one?
Motion to accept the staff recommendations for this one.
Okay, so we have a motion by Commissioner Reeves. Do we have a second?
I'll second that.
Second by Commissioner Moore. Any discussion on the motion? Okay, then I guess we'll vote on that one.
Do the Reeves motion to adopt the staff recommendations in item A5, the previously mentioned staff paper. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Ede?
Yes.
Yes. Phrase? Phrase, yes. Keefe?
Yes.
Keefe, yes. Ladd?
Yes.
Ladd, yes. Mazaros? Mazaros absent. Moore?
Yes.
Moore, yes. Warren? Warren absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Let me just check. Drops. Somebody's not waiting in
Oh, sure.
the area. Right, Madam Chair, there are 11 votes in favor, no votes opposed.
All right, so with that, the motion is approved unanimously. And when you're ready, we'll move on to the next one.
Madam Chair, so the next one is operating, facilitating, or advertising prediction markets. This was passed twice. And the second time it was passed, it repealed the first time. So what we're looking at is the second time we're attending the first time. They're pretty similar.
What did the prediction markets say the chances of it passing twice were?
I'll tell you, if somebody voted for that, you know that was insider trading. Yeah, so this is not going to go through it. Basically, it doesn't outlaw using a prediction market, but it does change the definition of bet. And it's not entirely clear to me, but there seems to be some room for the interpretation that wagering on a prediction market would now be classified as a bet, in which case consumers of prediction markets would be guilty of misdemeanor gambling. Don't quote me on that. What is clear, though, is that the people who operate a prediction market, operate, manage, or control a platform system for a prediction market, or facilitate a prediction market, or provide information or support services to a prediction market, or advertise or market financial or technology related to a prediction, guilty of a felony. And the advertising is in subdivision 3, and the others are in subdivision 2. And they all have the same statutory maximum, which is the default statutory maximum, since it's not articulated in the law. the default is that 5-year, $10,000 fine that we see a lot. So we are recommending severity level 4, both the advertising prediction market and operating or facilitating a prediction market. That's what felony sports book, yeah, which is the closest thing we could think of to an analogy.
Right. Does that cover all of it?
That's
Well, I
it.
guess we could have done that in the easy bucket.
Yeah, it's not crazy complicated.
Any discussion or questions?
Madam Chair.
Commissioner Castro.
I don't want to make it more difficult than what it is. I just think that the range of possibilities of damage that could be done in this type of betting is so broad that I would recommend that it be unranked
Oh.
to allow the judge to make that determination at the time of sentencing.
Say more about that. So, can you
I mean-
can you describe like what you could see as some of the range?
Well, you know, this goes as we've even recently heard, whether, you know, someone's going to survive to a certain age or, and so, which would inspire other people potentially to assault or kill that other person, depending on how they betted, you know, how it's affected even elections in certain jurisdictions. So I just think it's particularly broad. I mean, it can be the weather, right? Which can be something, you know, that really isn't going to impact anyone betting on what the weather is going to be like, as opposed to betting on whether or not someone's going to live or die. So I think the range is broad, too broad for us to pick a slot in the in you know in severity levels. So that would be my recommendation, that we leave it unranked.
Thank you, Commissioner Moore.
Madam Chair, I agree with Commissioner Castro. The equivalent, I guess the equivalent offense that the staff looked at here was felony sports bookmaking, which I can on one level sort of see the connection, but I agree with Commissioner Castro's comments that the potential consequences of this offense go well beyond felony sports bookmaking and go into, you know, some really concerning issues of public policy well beyond what team wins a game. I also had a quick question for Director Reitz. I saw that Director Reitz, we had one session law repealing another session law that was enacted this session. Was that after the lawsuit was filed against the first version or iteration of the law?
It was, and one update that isn't included in your materials is that there's now been a second lawsuit. I think the first lawsuit was withdrawn, and so there is a new lawsuit pending against the other matter. I just want to make 2 points, if I may, with respect to Commissioner Castro's point. One is, perhaps the fact that it's an immediate litigation from the federal government could influence whether you want to make it unranked. But another thing is that one thing that the second version did that the first version didn't is they both have very similar lists of sort of what constitutes a prediction market. But the first version was like, this is an example of what, you know, things like this. It was not an exclusive list. In the second version, the real version, it is an exclusive list. So those 9 or 10 things that are listed are the only things that would constitute a bet on prediction market. And because those are all enumerated, in theory, the commission could rank those differently. So you could look at that list, and I realize we didn't staff that, so it would be hard to do on the fly, but maybe I could just bring that up quickly here. So in theory, one way to address Judge Castro's concern would be to rank these differently. I mean, maybe you could say that an athletic event or a game played with cards is in a different category than a war, a death, assassination, or attempted killing. So you actually could, one of the reasons to make something unranked is that the crime could cover such a broad range, but conceivably rank it differently by which of those enumerated factors was involved in prediction. I think you could do that.
Commissioner Eve?
Thank you, Madam Chair. I would agree with keeping it unranked. I mean, I think your Director Wright's point is well taken, but the last category within Section 3, I guess subdivision 1, is events happening to a natural person or group of people, which itself is so broad that's going to necessarily, I think, defy ranking. So in the interest of, I think, the concerns that have been raised, I would propose to leave this unranked.
Procedurally, do we need a motion if we decide to leave it unranked? Commissioner, I'm sorry, you should be. Director Wright?
No, I think I misspoke on that. I apologize. I tried to find, I think that's from the previous version. I don't see in the actual statute that catch-all, the events happening to, maybe that was one of the differences that I just missed. I'm sorry, this is just a lot for staff to process in a very short period of time.
It is.
I actually don't see the events happening. Oh, no, it's number 4. Sorry. So I just put it as a catch-all at the end because it seemed like a catch-all, but yeah, right, it's still there. Number 4 is still there. Any event or events happening to a natural person or group of people.
I mean, I guess we could go line by line if you wanted to. But that seems like a lot.
Mm-hmm. Yeah. Yeah. Commissioner Fraze?
Well, so just to clarify that in our materials, the language or other events happening, that is in the statute somewhere.
Well,
that open-ended
Yeah,
thing.
it doesn't say or any other events, but that's kind of what I looked at it when I read the statute is number 4 kind of encompasses, it's sort of a broader category of many of the other things. I think an athletic event, an assassination, a war, all these things are events happening to people.
Anyway, I was just, with or without that, I think Judge Castro's point about the range of behaviors here, and just looking at the things, I was looking at the things in subdivisions 3 through 7 that are unranked. They're also quite diverse. So be consistent with that.
If we choose to leave it unranked, can we move on?
Sure.
Or do we have to
No.
do anything official?
Well, I mean, yes, you could just, your silence would leave it unranked, but the preferred method would be to add it to the listed unranked offenses.
Listed unranked offenses. Okay.
Yes, you're right that any offense that's not mentioned anywhere in the guidelines is also unranked.
Okay. So Commissioner Middlebrook, sorry, go ahead.
Madam Chair, I'll move to put this offense on the unranked list.
Okay. Commissioner Reeves seconds. Commissioner Middlebrook made the motion. Commissioner Reeves seconds. Any further discussion on the motion? Hearing none, we'll go ahead and vote.
So to the Middlebrook motion to add the offenses of operating or facilitating a prediction and advertising a prediction to the list of unranked offenses. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Ede, yes. Raise? Yes. Raise, yes. Keith?
Yes.
Yes. Ladd?
Yes.
Ladd, yes. Mazaros? Mazaros absent. Moore?
Yes.
Moore, yes. Moran? Moran absent. Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
So yes, Madam Chair, there are 11 votes in favor, no votes opposed.
All right, with that, the motion is approved unanimously. I think, do we have one more in that
Yeah.
area?
So, I may not have a future as a lobbyist, of the commission. So you'll recall that you had made a recommendation to insert a new penalty tier because the first penalty tier in the original version went all the way from $0 to $100,000. That may be mistaken in there. Yeah, no, that's right. So there was no intermediate penalty tier between $0 and $100,000. And you had made a motion to recommend a intermediate penalty tier. I talked to the proponent of the law, which was the Attorney General's office, Medicaid fraud division, and they agreed. They thought that was okay, and they drafted an amendment, and it got heard before the Senate Judiciary Committee. Unfortunately, by the time I got the fiscal note, the day after it had already been heard by the House, so I didn't have a chance to even talk to the House about this. But I thought we were okay because we got it in the Senate version, and the proponents were fine with it. The problem is I don't think it went anywhere in the Senate, and I think it was unrelated to this. I think it was a sort of a battle of commission jurisdiction between the Senate Judiciary Committee and another committee, and so they stripped the provision that the other committee had put in there and sent it back to the other committee, and it basically stalled out. So the version of the bill that we fixed never went anywhere. Meanwhile, I didn't have my eye on the Health and Human Services supplemental appropriation bill, which is where this ended up getting stuck into, and apparently the House version prevailed. Conference committee. So we don't have an intermediate tier, which means we have the ranking challenge that I was concerned about, which is you've got a whopping range at the bottom tier from no loss at all to $100,000. And I guess I'm getting ahead of myself. So what is this crime? This is the new medical assistance fraud crime. It can be, they've repealed the existing medical assistance fraud crime, which was a separate statute. It was also one of the theft crimes. It was a particular way of committing theft by false representation. So that's now gone. So a number of these changes that we're recommending are really just, changing the little Roman numerals around because they took out one of those that had to do with medical assistance fraud. And I've listed all the different 8 ways to commit this crime. It's several different ways. It's one of them is basically number 6 is aggravated forgery. Essentially, they've got all the language in the aggravated forgery statute except the intent to defraud, which is interesting because a lot of the other ones have intent to defraud. With respect to delivery of medical assistance services, and aggravated fraud is ranked as very level 2. Just kind of something to keep in mind that kind of supports the base ranking at severity level 2. So we have the 10-year felony for the general violation. You have the 20-year felony if the loss is to any victim is more than $100,000 but less than $1 million. And then we have a new $1 million penalty tier, which is, I say new, it's new to criminal law as far as I know. They have $1 million penalty tier. And we heard from the proponents that the intent of the $100,000 penalty tier was essentially to adjust the $35,000 penalty tier for inflation. So we're kind of treating that $100,000 penalty tier. That may be the way to go. There may be a recommendation from somebody like maybe this commission someday to change the $35,000 penalty tier adjusted for inflation to make it all $100,000 penalty tier, but that was our recommendation. So our recommendation was, our assumptions were, number one, what do we do about that big, $0 to $100,000? And we're like, well, the legislature didn't make an intermediate penalty tier. That's not the defendant's fault, essentially. So shouldn't assume that the defendant had, second level offense violations, but maybe you leave it unranked because it does cover. I mean, that's one of the reasons for leaving crimes unranked, if they cover a very broad range of loss for the victim. We're recommending ranking tier 2 at severity level 6, and that's consistent with other $35,000 penalty tiers, with the idea that this isn't really $100,000. It's basically $35,000 adjusted for inflation. That was the intent of the. And you may disagree with that line of thinking. And then ranking tier 3 at severity level 7, because we really don't rank property crimes above severity level 7, other than the identity theft that we're looking at the other. So you can see some of the other offenses that are ranked at severity level 7. So other than the conforming changes, that's pretty much it for these recommendations.
Great. Commissioner
I
Eden?
move to adopt the staff recommendations.
Second.
All right, so Commissioner Eid moves to adopt the staff recommendations. Commissioner Reeves seconds. Any discussion on the motion?
Can I just add one thing?
Great, yeah.
I think like if there's big cases that are charged above the $1 million threshold, they'll be paired with an unranked racketeering count, and they could seek higher penalties that way. So I don't know. I just offer that if anyone had any concern about how that was ranked.
I like that.
Commissioner Castro?
Yeah, so I just wanted to make the point that I know that now we're at a range of 100,000 to 1 million, and what had seen in the past is that the over 35,000 would get charged out multiple times. So if it was, whatever, 150,000, then they would charge out over 35,000, whatever, 3, 4, 5 times. I don't know that now with the range being 100,000 to 1 million, that it can occur. So we're only looking at one offense at 155,000 instead of 3 or 4. And of course, if you were found guilty of all of them, they would Hernandez them, and that would increase your penalty. I'm just throwing that out there for thought. I don't have any objection to the motion.
Okay, so thank you. I think that I saw Commissioner Ladd and then Commissioner Sextina, so we'll start with Commissioner Ladd.
Thank you. And just for point of information, my video is like a strobe light, so that's why it's off today. And so I'm saving everybody sort of the constant blinking. Maybe I missed this, but I'm curious why the fraud was originally at a 3 and now it's at a 2. I mean, I don't know why we're going down for that severity level 2 offense when it was previously at a 3 for the prior statute. And I look at some of the offenses that are in severity level 3, like check forgery over 2,500, which has the same stat max. That's a severity level 3. And there's several other offenses that are in there, and the property crimes there are over $2,500. And so I'm just wondering why the lowest severity level at tier 1 is at a 2 and not a 3.
Thank you, Madam Chair. Yeah, I mean, that's exactly the problem with not having the intermediate tier. I mean, if we had had the intermediate tier that you recommended, that would have been what we would have recommended at severity level 3. So the legislature is kind of, giving you the choice of, okay, are you going to rank everything at severity level 3 and sort of punish the people who would have been below that intermediate tier, or are you going to rank everything at severity level 2 and under punish the people who would have been above that intermediate tier? I mean, that's a tough choice, and that's, again, there's 3 options here. You can rank it at 3, you could rank it at 2, or you could leave it unranked.
But so, if I could just clarify, so the rationale for changing it from the current level 3 to a 2 is because they didn't give us an extra tier?
Well, it's so there is an existing 2 and there is an existing 3. The 2 is for the lowest tier, the 3 is for the intermediate tier. But they didn't give us the intermediate tier, so you don't have that tier to rank. Or I guess you could look at it, they didn't give us the lowest tier, so you don't have that tier to rank. But there's a missing tier there, so the commission has less flexibility on its ranking options than it would have had if the legislature had given us as many tiers as we had before.
Commissioner
Well, it just
Eid
seems
was-
to me that, I'm sorry.
Well, I just know that Commissioner Eid was raising his hand. I think it might have been directly relevant to what you were saying here.
Oh, yeah. Okay, I'm sorry to jump in front of Commissioner Sexton too. I was just going to say that just because I used to do this work in prosecuting Medicaid fraud, that a lot of the time with that lowest tier, if it was 5,000 or less, those cases would be charged against like individual personal care attendants or assistants who were maybe part of a broader scheme, but they were the individuals that were maybe committing the fraud, not in the same large amount that the person running perhaps a big racketeering scheme of a number of different organizations might be doing it. And my understanding too was part of the reason for changing some of this was inflation and cost of living adjustment between the amounts of $5,000 and $35,000 when that was originally enacted in today's values. And I would defer to what the Director Wonka at the AG's office sees now, but I think that probably they're seeing a lot of cases that are far exceeding the $100,000 threshold at the severity level 6 come in. And so we don't have that extra tier in between to distinguish at severity level 2 between the individual PCA defendant and someone maybe that's doing more. So I think Commissioner Ladd raises some good concerns, but that was the reason why I was in favor of the staff recommendations. I'm also open to leaving it unranked, but I'm a little concerned that someone without any minimum loss threshold could be sentenced at a higher level than, that was the reason why I didn't make that recommendation.
Commissioner Saxena.
Yeah, I just wanted to add a couple thoughts based on my experience with these prosecutions. So I've done a lot of these on the defense side, and my understanding is that this new statute is designed to provide the Attorney General's office with a more specific way to charge what their the types of conduct that they're currently charging as theft by swindle and as racketeering. And so, for example, number 4, that is a situation that they've had repeatedly, and they've charged it as theft by swindle, and they've had mixed results. The old statute, the 466, which did have, I think, a different severity level, I think this maybe goes to Commissioner Ladd's point, was really a limited set of circumstances, and the AG's office rarely brought that offense for the types of conduct that are listed here. And so I do think it makes sense to develop the severity levels for this new statute based on the theft standards, because those were the statutes that the AG's office were using to prosecute these fact scenarios. And then the other thing I just wanted to note is that because theft by swindle has been interpreted over the course of many years by the Minnesota court system it has been interpreted to be a continuing offense. And as the result of that, the AG's office will oftentimes just charge enough theft by swindle cases or enough theft by swindle counts to cover the time frame at issue for this continuing scheme or a continuing fraud. And they aggregate the loss that occurs during a particular time frame, usually 6 months, to be aggregated to determine the amount of loss, which would equate to the severity level. And so one question that this new statute raises is whether they'll be able to continue, this is to Commissioner Castro's point, whether they'll be able to continue to aggregate the loss into a single charge that covers a long period of time, or whether it will have to be charged as multiple counts. And then I think Commissioner Castro's concern would come into play, because obviously this being a new statute, the courts have not had an opportunity to determine how it should be charged, whether it's a continuing offense, and whether the loss that occurs over time can be aggregated. So I think it's a really important concern. I'm not entirely sure how we address that concern of multiple charges, but I agree with the staff's recommendation that this should be tied to the theft offenses that are already ranked.
Yes, Director Wright.
With respect to that point, I didn't mention this in the description, but there is a continuing offense provision. Subdivision 4. Well, for purposes of allocating the statute of limitations, it says any violation of subdivision 1 or 3 is a continuing offense. I don't know if that's helpful. The other thing I would just maybe ask more than point out is whether, when I look at the ways of committing the crime, I see if you look at these different ways, it's not obvious to me that 3 through 7 are necessarily even going to cause any. I think you can commit 3 through 7 without necessarily causing any actual loss to anyone, but you're basically breaking the rules to the program, or falsifying information that you still might be providing, the appropriate services, and everybody's okay, and the money's being used well, but you're not doing it the right way. So those would be, if the initial offense, if I'm right about that there's no necessary financial loss with 3 through 6, then those would be the offenses that would pretty much always be ranked at severity level 2.
If I could just note that at least when they've charged those things as theft by swindle, the government has taken the position that all of those things, even though they might just be program errors, result in the submission of false claims for reimbursement, and that the total amount of the reimbursement, whether or not the care has been provided or whether or not there's been any harm, constitutes loss to the state. That's the position the state takes with respect to those.
Commissioner Castro, did you have your hand up?
I did, unintentionally again.
Okay, thank you. Commissioner Price.
If I'm understanding what we're told about the repealed medical assistant fraud crimes, it'll pass the middle of page 21. There was basically a tier 1 with no minimum loss, 5,000 or less, but no minimum. That was at severity level 2. And if it was more than 5,000, so that's a minimum loss, it was severity level 3. So if we have a tier 1 with no minimum loss, it seems to me consistent with the way we rank the repeal thing, it would be at severity level 2. If I understand. Does that make sense?
Yep, that's and this is showing what's on the screen. Shows you what the things that are crossed out. Those are the existing 609-466 we didn't list the 60952 version as medical assistance fraud in the guidelines, although I think something to do. Yeah, it was 2 if for no minimum loss. 3 if the loss was over 5,000, but less than 35.
If I could make a suggestion, this is the sort of thing where it's difficult to know, since the law was not written in the same structure, what the intent was with that bottom tier. So one way to go is to adopt the staff recommendation. We're going to a public hearing next week. If that is not what was intended, we should get the feedback at that hearing, and we could adjust it at that point. If they really were looking for a 3, we could get the feedback at the hearing that that's what they were looking for, and we could adjust it. That's one possible way forward.
I'm sure. We've been told by legal staff, though, that if you are going to make a change, it generally has to be connected with the public. So if nobody says anything, it would be
Correct.
I'm not going to say improper, but it would be highly unusual to make a change.
Right. I'm suggesting this seems consistent with the way the law was written. If it's not consistent, then I would expect public comment to be provided to us to request a different ranking.
And in talking, I'll just say, talking with the unit, they seemed like they were okay with this. This wasn't necessarily different from what they were expecting when they were. But maybe I shouldn't say that because I'm not a spokesman for the Medicaid project, but that was my impression.
Yeah. So does anyone want to make a motion on this one? However,
I think that,
actually there is a motion. Oh, I'm sorry, Commissioner Eid.
oh, there was a
Did you
pending motion.
make
I
a
think we were
motion?
in discussion.
Oh my
and
God, I completely lost track. So you had what was your motion?
To approve the staff recommendations, and Commissioner Reeves, I think, seconded.
Oh my goodness. Wow. I'm losing it. It's getting to be late in the day. Thank you so much. All right. Is there any further discussion on the motion? Hearing none. Let's go ahead and vote on it.
It's to the
Thanks.
Eid motion to adopt the staff recommendations in item A7 of the aforementioned staff paper. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Castro, yes. Eid?
Yes.
Eid, yes. Phrase?
Yes.
Phrase, yes. Keefe?
Yes.
Keefe, yes. Ladd?
No.
Ladd, no. Zaros? Zaros absent. Warren?
Yes.
Yes. Warren? Warren absent. Mueller?
No.
Mueller, no. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. Madam Chair, there are 9 votes in favor, 2 votes opposed.
With that, the motion is approved. And I believe that takes us to the end of document 4 for item 4, right? And then we have, don't you have the technical changes, right? Sorry, if I can find my agenda, there it is.
So we did go through these technical changes. This is updated. What the updates are. Okay, so this was correcting the definition of the presumptive range. So this is because the commission in its 26 guidelines modifications is now adding the ranges to the presumptive state sentences. So the gray squares are now going to have the full range. So just correcting the definition of presumptive range, which limits the presumptive range for sentences that are presumptive. Says now. So this is a change. The other elements of this paper were presented to you in the May meeting. The first is to refer to first degree murder as including custody offenses, because we're only discussing offenses that were on the sentencing grid, which first degree murder. The second is removing an obsolete example of comment. Third is removing repealed marijuana stamp, controlled substance stamp tax stamp laws exist. You have them in the guidelines. And then B is really almost just information, previously adopted technical. So we already approved those, so those are good.
Okay, so for this one, these are primarily technical. We've seen most of them, just that one is new. So I think if someone is comfortable, we could probably take a motion for the whole package, to approve the whole package.
Motion to accept.
Did you, sorry, Commissioner Reeves, did you make that motion?
Yes.
Okay, Commissioner Reeves makes that motion. Do we have a second?
Second.
Second by Commissioner Eid. Any discussion on the motion? Hearing none, we will take that vote when you're ready.
Right, to the motion to adopt recommendations in the staff paper. The staff recommended modifications, sentencing guidelines, in the staff paper called Sentencing Guidelines Technical Modifications, dated April 27th, 2026, and updated May 28th, 2026. Middlebrook?
Yes.
Middlebrook, yes. Castro?
Yes.
Yes. Eid?
Yes.
Eid, yes. Phrase? Yes. Phrase, yes. Keith?
Yes.
Yes. Ladd?
Yes.
Yes. Mazaros? Mazaros absent. Moore?
Yes.
Moore, yes. Moran? Mueller?
Yes.
Mueller, yes. Reeves?
Yes.
Reeves, yes. Saxena?
Yes.
Saxena, yes. Mitchell?
Yes.
Mitchell, yes. I'm sure there are 11 votes in favor, no votes opposed.
And with that, the motion is approved unanimously. All right, we did it. We got through what we absolutely needed to get through today. And we still have 25 minutes left, so you're gonna have to keep your brains working a little bit longer. We do have the comprehensive review ranking project. Do you have enough time for that?
Well, I was
Or
just,
would you rather move it to the next one?
just sign languaging the
Yeah.
research staff on that, Madam Chair. We had discussed this. It's kind of like right on the edge. So,
Yeah.
I mean, we might have enough time to go through it, but it might be rushed.
So we can wait till July. Okay. The signal I'm getting is let's wait on this till July, which works for me. All right, so we'll bring that back in July. Item 7 is committee updates. So I will say that the committee working on the Hernandezing issue has not yet met. And for those of you who are on that committee, I will be sending you an email with some potential dates to set a meeting in between the meetings. So I just wanted to give you a heads up to look out for that, and we'll get that scheduled. You want to report?
Yes, so the restructuring committee, I have not sent out a poll yet. I wanted to, honestly, I was surprised by how much legislation passed this session. And was hoping to sort of roll this in so that what we're changing is essentially the 2026 guidelines, not the 2025 guidelines. That obviously, I'm not presuming that you're all going to adopt these changes that are when you make the final decision in July, but that's usually how it goes. So I based on this, I was going to incorporate these into the guidelines. One possibility is that we might meet after the public hearing, if everybody's available for that date, planning to come.
So that's for the committee that's working on the sort of stylistic revamp of the guidelines. I can't remember what we called that group.
Restructuring.
Restructuring. So I'll let you coordinate with that group. So normally, actually, I'm sorry, I should have paused because we have a lot of members. A lot of new members. I should have paused and just taken a second to recap where we are. So with all of the rankings and things like that we just voted on, those are all preliminary decisions. And that is our current, this is where we're thinking that we're going to place these offenses. Those will now get published. And the reason we have like a bigger break between this meeting and the next one, because we have to have them posted and publicly available for 30 days before we can make any decisions on them. So they're being published. We'll meet twice in July. The first time is a public hearing, and when the issue is controversial, those hearings take a long time. When the issues when the issues are not very controversial, they go very quickly. And so it really just depends on how many people decide to make comments. Those comments can either be done in person or in writing. And so we won't really know until we get to that day what that day would look like, but it could be as quick as 15 minutes or as long as an hour, like whatever it could take. So what Director Wrights is proposing is that if you're all coming in for the hearing anyway, there might be time to meet after that because you're here or you're on deck. Ironically, I will not be here for that. It'll be the first hearing I've ever missed. But I have to do some travel for my day job. So Vice Chair Middlebrook is going to preside over that hearing. All that information will be available for anyone who's unable to make that hearing. A quorum is not required, but you can review the record of that hearing following if you're unable to make it in person. Then we meet a week later, and then we'll take final votes, final action on all of those rankings. So if there is any input that might change our mind or persuade us to look at ranking something differently, we'll be doing that at the meeting a week later. So that's just kind of the overall process and how that works. Is there any questions from folks on that? Okay. I probably took your executive director report, didn't I? I tend to do that.
Totally did. I was gonna say that. Yeah, other than adding the dates to that, so that the dates are July 16th for the public hearing, all required in this room. July 23rd. Meeting. That's where you actually change the sentencing guidelines. So we do need a quorum again for that. Thank you for having a quorum today. And we'll be looking for a quorum. Then August 1st is the Saturday, but we'll be publishing the 6 sentencing guidelines. All these crimes take effect. So.
Great. Anything else?
For the executive director's
Yeah.
report, well, we do have a document in your file that talks about other laws of interest to the commission. I'm not going to
Oh, right. Thank
go
you.
through those. It's not. I don't. Some of them. It says may be of interest. It doesn't say will be of interest. Some of them may have no interest to you at all. Some of them may be of interest to you. There is a change to the definition of identity theft that adds forged digital likeness. That is I think somewhat interesting. And yeah, I think I might have mentioned the possibility at last month's meeting that there was a possibility that the jurisdictions whose protective orders qualify for second-degree murder violation of a protective order have expanded. But, yeah, other than that, you're welcome to read that at your leisure. I mean, nothing that really directly affects the sentencing guidelines, and certainly nothing, you know, true to form throughout this session. None of the commission's recommendations were acted on, and I don't even think there was a bill that would have acted on any of the commission's recommendations or blocked the commission's proposed modifications to the sentencing guidelines. So the modifications will go into effect on August 1st. Notably, significantly, the commission downranked assault in the first degree to severity level 8 because that crime did not contain intent to inflict great bodily harm, and recommended that the legislature reenact, I guess, because it was previously an offense of intentionally inflicting great bodily harm, which the commission would have ranked at severity level 9. But the legislature never created that. So in effect, even though it wasn't fully the commission's intent, assault first degree has completely been down. Severity level 8, effective August 1st. So the other thing that I wanted to include in my report, I mentioned erroneously last month that too bad, but the NASC conference in August will not be in Santa Fe, New Mexico. It will be in Albuquerque. And the other thing with that is we've discovered how expensive it is to fly since the Strait of Hormuz has been closed. So we may have some challenges in funding all of the commission members to that conference that we were hoping to fund, but I'll notify you if you've been selected, and then we'll be looking for a response from you on whether you're able and willing to come to the NASC conference in August. We'll provide you all the details if you have been selected, and then we would ask for a pretty quick turnaround on that so we can select someone else if you're not. I do have a system for who I ask. It's pretty much, once you get asked, you kind of go to the bottom of the pile. So the people who get asked are generally some of the non-commission members. And that does conclude.
All right. We also did put in a proposal to cover the comprehensive review as a session at NASC, and we were accepted. So we'll be figuring out how to do that with the university staff, University of Minnesota. So a joint session just to talk about the whole review and some of the research that we used along the way. So that'll be interesting.
Yeah. Just say one other thing. It's that the as you may know, the legislature created the Minnesota Sentencing Guidelines Commission, Nation's first Sentencing Guidelines Commission in 1978, and the staff Minnesota Sentencing Guidelines Commission has hosted the NASC conference in the past, and we are mulling over the possibility. I'm not making any announcements at this time, but we're mulling over the possibility of hosting the NASC conference, and probably be looking for some cooperation from the University of Minnesota Law School in that regard, but hosting the NASC conference in 28, which would be the 50th anniversary of the Sentencing Guidelines Commission.
Amazing. Yeah.
So that is a lot of work for the staff, but it's exciting to do that. I'm assuming I have never hosted that, but just something that we're talking about as staff, and just want to let you know that.
Not everybody may know, but Professor Wrights pulled together the sentencing commissions for a meeting just to, learn from each other and about each other. When there were very few commissions in the nation, and they decided that was a good thing, and that is how NASC was born. So it would be really appropriate to have it here.
And maybe people aren't aware, there's no there's not really a thing with NASC, right? There's no staff or anything like that. It's basically the sum of its parts, which is all these different sentencing commissions that, would volunteer and get together, and create something. And if you've never been to the conference, it really is eye-opening to see sort of how all different states kind of do the same thing in dramatically different ways. So just that'll be interesting if we can. All right, so let me see who we've got
I think we're down to
online.
public input.
Yeah, so members of the public, it looks like you all ought to be able to raise your hand. If you'd like to make a comment to the commission, we have an opportunity to do that for you at this time. But I will need you to raise your hand so I can unmute you, otherwise. There are no members of the public in the room, Madam Chair, and I'm not seeing anybody who's online to whom our staff raising their hands.
Okay, so that will close the public comment period. So again, we will see you in July, public hearing first, meeting on the 23rd. I think the public hearing was 16th. Is that what you said? Have a wonderful intervening month. And with that, this meeting, unless there's an objection, this meeting is adjourned. Thank you.
So great. Good to see you.